Welcome everybody. I am Becca Hamstra. I'm a financial advisor here in Tucson, Arizona. I also have a lot of clients up in Spokane, Washington, and throughout the western U.S. I am a specialist in widows and widowers. So I really love my clients who are older and dealing with finances on their own and have questions and would like some help. So today our topic is dealing with loss of a loved one, and particularly loss of a spouse, but it can be any loved one. So I have provided for all of you a little folder, and it says Anticipate the Unexpected. If you were to open that and go to the very back of it, there's a pocket, and in that pocket is the book Surviving Spouse Checklist. And we're going to try to work our way through that today. Hi, welcome. Come on in. So if you first open this up, it says in the first week. But what I have consulted with Eunice Bradley Fox, who is a grief counselor, and and I have talked about it a little bit, and she said, you know, when a death of a loved one happens, it's so overwhelming. And you're so stressed and you can't think straight. So really, instead of saying first week, I would say this is what you want to have in place before the death occurs. So in a convenient, accessible place, not a safety deposit box, because a safety deposit box can get locked as soon as there's notification of a death. And so unless you are also an owner on that box and have the key, you got to go through probate to open the safety deposit box. So it's the worst place to have a will. Hi, welcome. Hi. Come on in. So, you know, if you keep the will in a safety deposit box, and then you can't go to court to probate the will to get letters testamentary to open the safety deposit box because you don't have the will, you end up going to court as if it is there's no will at all. So you start with that process and then have to change it. And I guess I should mention that I am a licensed attorney in Colorado and Washington and have practiced law for a number of years, but actually I have done financial advising now for 21 years, so I have not actively practiced in the last 20 years. But that's the process, and we don't want to have to go through that. So in a place that's convenient to you, convenient to the survivor, we want to have where it says immediately notify financial advisor, insurance agent, attorney, and accountant. You really do want those names and numbers really first page of a notebook or a file that is all your kind of important information. So have that file, and in that file I would recommend that you keep many of the things shown in the column right across from where it lists those, immediately notify. You really want to have things like your marriage license, birth certificates, the will or trust, or a copy of the will or trust so you know who's in charge, any mortgage documents, deeds, trusts, insurance policies, your bank statements. You don't really want to keep all of your retirement and account statements, but at least have a list that says who has these accounts, and maybe an account number, and then things dealing with the military. If you have military service, there are veterans benefits, and so discharge papers and retirement things, they're available to you. So you want your survivor, or if you are the surviving spouse, you want these things available to you on your spouse, so it becomes easier when that time occurs. It's not going to be easy, but easier. That's what we're talking about. So, one thing Eunice and I were discussing is that sometimes you get an insurance policy and then you're making payments every month or every quarter or whatever, and pretty soon you forget what kind of insurance it is. So you might want to make sure that if you're paying an insurance company something monthly or quarterly, write down and keep in this file that this insurance is life insurance or disability insurance or long-term care insurance, something, so that, you know, when you're all befuddled and stressed out, you can go, oh yeah, okay, that's what that was for. And you don't get misled thinking you have something you don't, or forgetting about something when it could benefit you.
And if it happens to be a disability insurance, make sure that you stop paying it after the person dies.
Oh, good point. That's right. That's right. A disability insurance, or actually when they become disabled, premiums are waived. So if your spouse is disabled and you have a disability policy, you want to contact that company and start getting benefits and stop paying premiums. And certainly after the death, you want to stop paying the premiums. Yeah, good point. So I do like the very bottom statement on the far right column where it says immediate financial needs. These are the only two things you really need to care about right off the bat. And the first is funeral and burial expenses, and then making sure that you have some form of income coming to you. Because, you know, the house still has to get paid for, and you need groceries and things like that. So you want to make sure that if you are really living on your spouse's Social Security, you know, as soon as you notify them of it, they stop that. So you got to make sure you've got some things in the savings account or money available for at least a couple of months of income, just so that you're not putting yourself under any pressure.
What is a reasonable amount of time before you notify everyone? I mean, obviously, it's not going to be the first thing on your mind, but, you know, they would have credit cards and Social Security and car insurances.
And all of that comes up a little bit later.
Oh, okay.
But, and even in this immediately notify, I mean, my clients generally do let me know right away, and I find that's important because then I can run the list of holdings and values as of the date of death, which becomes important for estate tax purposes and for transfer to beneficiaries. So if you have a financial advisor, it's great to notify them right away because you lock in those things and nobody has to do historic research, which you can do, but you know, takes more time and you usually have to pay for that time. So notify your financial advisor, and I agree with notify your insurance agent because there may be immediate benefits you can get. The attorney and accountant, I don't think you need to notify them right away. You don't have to deal with probate and you don't have to deal with, you know, the tax issues and stuff right away. So I would actually say they don't have to be notified right away, but your financial advisor and your insurance agent probably should be pretty high on the list. So if we turn the page, we now look at weeks 2 to 4. So this is the first month. And things are still, you know, pretty stressful for you, and it's going to be difficult. I will say that I have found that the family services on any Air Force base, probably any military base, are extremely helpful and and available to you if you have veteran services, if you or your spouse is a veteran. They have money for burial, and you might be entitled for, you know, a burial at Arlington and things like that, and they are very, very helpful. The other thing is funeral directors are very helpful too. They generally will help you write an obituary and, you know, put together the service. But again, planning in advance, if you could pre-plan and prepay for your funeral or burial, you help your surviving spouse so much, and your kids. And we always get into the argument sometimes about, okay, who is the funeral for? Because if the kids do it, well, you know, they have their desires and religious beliefs, and if it's for the parent or the surviving spouse, they have their lifestyle and religious beliefs. So if you can kind of line that up in advance, you can save the family some disagreement and difficult times in an already stressful time. Also keeps them from being taken advantage of in like purchasing the coffin and things like that. It can be very, very costly. And if you've already prepaid for something, you don't have any of those issues. So I do advocate for that. But now within the first month or so, you really do need to notify Social Security, because there will be survivor benefits, and you get the greater of spouses, half of spouse's benefit or your benefit based on your work history. So, and as soon as they're notified of a death, they're going to stop payment.
I think that's the first day. I think the funeral director, in fact,
Does that?
notifies them.
Okay, so that's, so they'll be notified then to stop benefits.
Immediately.
You need to go into Social Security to start your benefits. And that really should be in the first month, because you want whatever you're entitled to. And then, if your spouse was employed or self-employed, you're going to need to deal with that. There will be benefits from an employer. If they're self-employed, hopefully they have a succession agreement. Might even be, you know, a buy-sell agreement funded with life insurance to pay for it or something like that. So, and those businesses continue to go, and those jobs have to be done by somebody. So that kind of rises to the top and is something you'll have to deal with. They go on to talk all about, you know, looking at your assets and changing your portfolio, and, you know, and then over on the other side, you're retitling your home and car loans and stuff. I really don't think that has to be done in the first month. Do you, Eunice?
I don't think so.
No, that could wait a little bit longer.
You've got a lot going on.
Yeah, so you could put that off a little bit more.
A word to the wise, it's good not to sell your house in the first year if
Right.
you can get away with it.
Right, right,
There's too much grief involved in this.
yeah. So you will see on the page 3 then, we're talking 1 to 6 months. Okay, now this is when you're gonna start to be able to tackle some of these things. So this indeed is when you're gonna want to make an appointment with your financial advisor. You're gonna wanna take a look at your investments, make sure it's appropriate for you. I find with most married couples, one spouse is very conservative and one spouse is very aggressive. And so when one of them passes away, we definitely want to adjust that portfolio. Make sure that you have enough income coming to you. And it's also a good time to be talking about, you know, what are our plans for children, funding for them down the road or immediately, education costs, and all of that kind of thing. So that is a great thing to do. You want to, at some point, begin settling the estate. Now's the time when you're going to talk to your attorney. Now, estate tax returns are not due until at least 9 months after the date of death. And that's because there's a provision in the tax code that you take a look at the asset value on the date of death and then 9 months later. And you file with whichever one is lower. So that's why you never do estate tax returns until at least 9 months later. Yeah. Now, very few of us are probably in the position where we have to worry about estate tax, because right now that's an estate of $5 million. But you also have to consider that the IRS considers your estate everything over which you exercise control. So if you have life insurance in your name and it's a $2 million policy, well, boom, you got $2 million right there. And if you have a very nice house worth another $1.5 million, okay, you know, it's possible we could be bumping up against that. So you do want to be careful of that, and if you're in those situations, you need to talk to your financial advisor and attorney, because there are ways to structure things so that you still have it, but it's not considered under your control and included in your estate. So we can do that. But those are the things you want to start looking at, and settling the estate, which means making sure all the bills are paid, making sure, you know, the medical costs, ambulance costs, everything has gone through, and those take some time. Medicare is terrible about reimbursing for, you know, a good month or two. So, you know, you're not going to be able to settle those debts until 3 months later, which kind of works out because you're in no position to do any of that or argue or, you know, point out their errors until you've got a couple of months under your belt. Grief counseling is good to get started maybe after 2 or 3 months. You need those first couple of months just to barely survive. Keep your head above water. Right, Eunice?
Yes,
Yeah.
usually maybe after 2 months.
Yeah. Okay.
Because if you go too soon, people are largely in shock.
Yeah.
After about 2 months, relatives have gone home, people have, and it's, the grief is set in and you realize, yes, he's gone. I'm not going to, this is permanent. I need to deal with this.
Yeah.
And your relatives are tired of listening to you, and wonder why you haven't gotten over it yet. There's time to talk to other people who are in the same situation.
That's good to know. Yeah, and there are individual counselors or there are groups. And there are groups through different organizations, particularly churches. They have one that lasts 12 weeks, and that really helps. And so, one of the things that Eunice had told me is that it's nice to be in a group because you realize you're not the only person going through these things. And if you feel like you're stuck in your grief and you're feeling guilty, this is a great way to help you get unstuck and not feel guilty. You'll need to, you know, forgive yourself and forgive the deceased for anything that may have gone on, and it's a process. So that can all start at about the 2 to 6 month period. Those are good things to do. All right, so then we flip the page and say, okay, now it's more than 6 months to a year, and like I said before, the value of the estate, certainly if it's a taxable estate, we want to wait 9 months. If the stock market takes a big drop or the housing market goes down, you know, you definitely want to take advantage of a lower value in the estate. If you have to file an estate tax form, that's a Form 706, and your attorney will take care of that. You don't have to worry about that. And then it's really time to kind of hold the family financial meeting. And that's when we would talk about planning for the future and any charitable contributions, education accounts, anything that's of value to you. You really do want to have your children involved in some of that if you have children, because otherwise sometimes they get a false sense of entitlement, or they assume that you're loaded and you can just bail them out of this, that, and the other thing. And a real honest discussion about, you know, how much money does it take to provide, say, you know, a $5,000 a month income. You really need to understand all of that, and that it does take a big chunk of change. So we want to do all that and start talking about the future, and at that point you may be ready to actually start looking at the future. And so, as Eunice had mentioned before, try not to sell the house until at least a year has passed. Now, if it's a parent who's passed away, that same year does not necessarily hold. You can sell the house. But if you and your spouse or partner were in this house together, you need to go through every season and every holiday alone and realize what that is now. That's part of the grieving process. So then it would be time to start going forward. And some of the things Eunice had mentioned to me too is, don't be afraid to cry. Grief is a very important part of the journey, and realize that you're never going to be who you were before. You will emerge a new person. And I hadn't ever thought of it that way, but yeah. So you have to, after about a year, you're starting to say, okay, I think I'm ready to move forward. And understand everybody handles grief differently, so be patient with yourself and with others, and try to tell them that, you know, not to assume that you will react in exactly the same way they will. Everyone is individual and everyone is different. So, one other thing I just wanted to mention, somebody sent me an article and I meant to copy it and I forgot it, but about writing obituaries and how now that's becoming a source for hackers to get your birthday and your children's names and things like that. So if you're going to do an obituary or something, you might want to be very careful about some of that data and not just say, you know, what high school you went to and your children's names and pets' names and you know, all those things that now are security questions. So we are being more judicious in our obituary information. So, yeah. So the outside folder that these little booklets came in, that's just kind of preparation, giving you some ideas that, you know, even though we find these life-changing events are unexpected, unfortunately there's something we all have to go through. So it does help to create a plan and, you know, work with your advisors, trusted advisors, talk to your children about things, make sure that you're comfortable with knowing, you know, what the bills are and where the money is and how things are invested and what insurance you have. Those kinds of things are very, very helpful. So, I'm hoping that you have some questions. Yeah, Don.
I do. Trusts.
Yes.
Because a trust is what's being recommended to me right now.
Okay.
And, or if anything happened to my wife, they're recommending that they immediately place my daughter on, we only have one child.
Okay.
So that we immediately place our daughter as essentially on everything that I would have, bank accounts, investments, everything, so that there is no issue of ownership. If anything happens to me, she's already an owner. So there's no succession line of how the assets, they're saying, put her on the house, put her on everything, you know, once the other spouse is gone, there's just you. If you're gone, who cares, right? I mean, she's going to get everything ultimately anyways. Make it as easy as we possibly can. I'd not heard that before.
Yeah.
But it really made just like a lot of sense to me when they said it.
Well, here's my lawyer answer. That's a yes/no answer.
Okay.
Yes, making a child a joint owner on things makes things easier, but the downside of it, and there are a couple of downsides, in most states, if you put a child as a joint owner on real estate, you have to pay an excise or transfer tax based on the value of the property at that time. And so that can be a real costly thing. The second thing is that when you name someone as a joint owner, creditors and former spouses, and current spouses in a divorce action now can attack all those assets.
Wow.
A much smarter plan is either a trust, which, you know, can be good or can be bad depending on what's going on, or right now, I find this amazing, in Arizona, you can do something called a beneficiary deed for real estate, and they have a similar form for your vehicles with the Department of Transportation or whatever, motor vehicles, where you can name a beneficiary if something happens to you, just like we have transfer on death accounts for financial investments, and, or payable on death contracts like your IRA, your 401k, all of those. You name a beneficiary, they show their identification and a death certificate, and it transfers. Now, that doesn't get rid of a state tax, because you could exercise control, but neither would joint ownership. It is just an easy transfer, and yet it's not an asset creditors or former spouses or anybody could attack.
Until she took ownership of it as a result of your death.
As a result of your death.
Okay.
So certainly in Arizona, there are additional tools to help you avoid probate and avoid the pitfalls of joint ownership.
Would that make sense to put on even if you had both existing spouses? If you only had, like in our case with one child, would that make sense to put her on there even when Janet and I are both still alive?
I would say yes, because if there's a common
Well, yeah.
catastrophe, a car accident or an
God,
airplane
She could
crash,
shoot me.
well, well, that could happen too.
Yeah.
And,
Pretty likely with her.
and certainly when we do transfer on death on investment accounts, we always have, primary and then contingent
Right.
beneficiaries. So you could name, spouse and then child as contingent on things if she's not already a joint owner, your spouse, or the two of you can name the daughter as the beneficiary. And that takes care of all of those issues.
Is that just real estate in the case of autos, or is it other properties as well? Would it be other
As far
types of
as-
properties? Stocks, bonds, precious
Oh.
metals, artwork?
Yeah, well, the stocks and the bonds in an investment account, nationwide now, you can do a transfer on death,
Okay.
which turns it into a payable on death
Right,
contract.
there's no probate, there's no
No
will, there's
probate.
nothing, we don't need any of that.
Right.
So would you
Now, I'm
have,
not sure about artwork and precious metals. Probably those you would have to probate, go to probate.
so then the will would not require you to have, or excuse me, a trust won't require you to have a will?
Well, you find out you still need a will. It's called a pour-over will.
Okay.
Because everybody always forgets something. And so you need the pour-over will to pour it into the trust.
Okay,
The other thing to be very careful of is anything like IRAs, 401ks, and annuities. If you name the trust as the beneficiary, they cannot do the stretch, which spreads it out over a beneficiary's lifetime. So instead, they have to take all of it out,
Okay.
and it gets taxed at the trust rate of
Okay.
tax, which is 37% at $8,400 of income.
right,
That's ridiculous. So you never want those assets in the trust. But we used to always say you needed a trust if you had property in more than one state, because you'd end up probating in multiple states. And as far as I know, that's still true for most states. Arizona's the only one I've ever heard of that has this beneficiary deed. And I practiced law in Colorado and Washington, and when I was in the Air Force, I was stationed in California. So I knew some California law. They don't have anything like this. So I'm betting other states don't have
No.
this provision. It's a unique Arizona thing. But it might obviate the need for a trust. Unless you still own property, say in Michigan, and have to do it for that
Right.
purpose. The other situation when you really want a trust is when you have children from different marriages. And so it's the only way to protect children from various marriages.
and one more final question.
Yeah.
In the case of powers of attorney, we have medical right now, and then we have essentially financial.
Yeah.
So we have, my wife has both on me, I have both on her.
Right.
Is there any other ones that we should have that specifically, she talked about getting a do not resuscitate is a one on there as well, because that's an additional condition. Are there any other ones we should have that you can think of?
Well, the durable power of attorney for health care is a very important one, because most medical professionals prefer to actually have someone make a decision
Right.
rather than the living will or, directive. But the directives, the do not resuscitate directives and things like that are helpful to the person making that decision. So it never hurts to have those extra documents, but you don't really need them if you have a durable power of attorney for healthcare and then the power of attorney over financial stuff. Now, understand the difference between those. Normally, a power of attorney expires when the person dies. So, your power of attorney is only while you are living and while you can still make decisions. The durable power of attorney is a unique thing that is in place. You're still living, but you're not able to make the decisions. And so,
Okay.
that's there. And so once you die, the power of attorney over your investments is extinguished. It's gone.
Right.
And so that's when the will kicks in, or your
The
transfer
trust.
on death paperwork comes in, or the trust can
Okay.
kick in.
All right.
So, yeah. But healthcare directives are helpful. The durable power of attorney for healthcare is what everybody really, really needs. So, yeah.
Okay. Then I have one final question.
You said the last one was the final question.
Well, actually, you brought up something else that actually is an issue for us. My wife has got lots of medical-related issues.
Okay.
And because I'm her primary caregiver, she gets really, really good care because I take really
Yes.
good care of her. The problem being is that if she passes away, which is likely going to be far earlier than hopefully I do,
Right.
there's no one around to take care of me.
Right.
So they have a provision on our will that'll eventually go into the trust, which now funds a
Long-term care.
long-term
policy.
care for me because I won't have her to take care of me like I take care of her.
Right. What a great segue. Thank you so much.
Well, no, because I was interested in that because I was reading here and it talked about long-term care.
Yes. Long-term care policies are available and they provide the basic essentials of living. So they provide money to help caregivers help you or help your spouse bathe, eat, go to the restroom, get dressed, those 7 essentials of living. It is not for nursing care, doctors, those kinds of things. But it will pay for a nursing home or an in-home caregiver or an adult family, caregiving, those kinds of things. And I brought an article on this because this is something I think is important, and this month it's my focus for all of my clients to pay attention to long-term care, and if you don't already have it, let's talk about it.
So you could pay thank you so much. So you could pay a family member to do this?
There are provisions where family members can get compensated under the COPES program, but it is more difficult for family members to get it. It usually is used for respite care, but if you have a long-term care policy, then you can pay to have people come in and care for your loved one or for yourself. So, and generally we highly, highly recommend it, especially for a surviving spouse.
Yeah.
Because you're right, there's no one there to give caregiving other than perhaps children, but the toll it takes on caregivers is phenomenal. They probably age 5 to 10 years for every year of caregiving they're doing. So having a long-term care policy for both of you really is helpful for whoever is the caregiver, and then also for when they're alone. And plus you get usually a discount if you have a policy together, husband and wife. You can usually get a discount on the premium. And traditionally it has been a unique unique insurance package. You pay the premium, you get the benefit. But if you don't need it, well then that money is just, gone. Now they have developed a couple of different ways where you can get long-term care insurance as a rider on either a life insurance or an annuity product. And in the article they talk about it and say, well, it may be more cost. The policies I've looked at, I have not been impressed that it's an exorbitant cost, and it allows you to keep the money if you don't need it and pass it on to your beneficiaries if neither of you need it for some reason, and it just doesn't feel quite like you're flushing money down the drain. The other thing is, because long-term care insurance is a privilege, it's not a right. No one is required to provide you with long-term care insurance. You could apply, and based on your health history, you could be denied. They don't have to do this. But the requirements are much less stringent when it's a rider on an insurance or annuity policy. So somebody who already, has a little bit or has a family history of osteoporosis or dementia or, something like, incontinence or something, there's no way you're going to be able to get a long-term care policy on your own. You may be able to get it as a rider on an additional policy, on a life or an annuity policy. So there are some things to think about. And, they were saying, I was just talking with a client yesterday whose mother is now in full-time nursing and she has dementia. They spent $83,000 for her care last year. So, yeah, I was a bit surprised too. I was thinking the average is maybe 5,000 a month, which would be 60,000, but they actually spent 83,000. So, you know, the premiums might look expensive, but my goodness, if you need this kind of care, it can get swallowed up in a hurry.
Yeah.
So it is well worth it. So that is something that I have, you know, as a handout for all of you. And then if you like, I have other money talks coming up. I have next month a guest speaker, Jim Whitehill. He is a real estate, real property, and probate attorney, and he's the one who educated me on this beneficiary deed. And I said,
Yeah.
oh my goodness, Jim, we have to get the word out, because I think that's the coolest thing since sliced bread.
Yeah, absolutely.
And it's not available in most states, only available here in Arizona, which is great. So, and then in June, I have a gal coming in to talk about reverse mortgages, which is something that's completely changed in the last 5 years or so. It used to be a real racket, but then the FHA got involved. And so they have completely revamped it now, where you retain title to your property. They are limited in how much they can give to you as a loan. And so it starts at like 50% of value if you are, say, 60 years old, and then goes up, but it can be no more than 80% of the value when you're in your 90s. So there's always some house value left. You're never completely wiped out. And it still can pass to your own heirs and things like that. So that's a very fascinating, changing area of the law in response to older Americans. So I'm excited about that.
Yeah.
Yeah. Any other questions?
Yeah.
Is this long-term care insurance, if you add it as a rider, is it still the same cost as it would be if you just went and got it by itself?
I actually found it to be less expensive on a policy that I ran quotes for a client of mine, married couple, both of them like 59, 60 years old, and we looked at long-term care for each of them, and the premiums were about $3,500 each. When we looked at the annuity with the rider, it came through that the cost would be closer to about $2,500. And this particular company offered 3 times your initial purchase amount in long-term care benefits. So if they put $100,000 in, they would have $300,000 in benefits, which even at $80,000 would last a couple of years.
Yeah.
So I have not found that they're necessarily more expensive, and I love the idea that you have money at the end of the day, and it grows, and you can get it back if you don't use it, and you can pass it on to your kids. So, anything else?
Excellent.
Thank you. Well, I'm Becca Hamstra. I'm a financial advisor here in Tucson, Arizona, and I thank you for joining us.
Thank you. Yay!